and more than 50 LLDs. So he is Fulbright scholar, Scalberger scholar of Australia, and he retired in 2002 from Andhra University at the age of 60. Then he went to NASA, National University, Hyderabad, as registrar. He worked there for 4 or 5 years. Then he is the founder, Vice Chancellor of Chanakya National University, Patna, for 10 years. He is the founder, Chancellor of Damodaram Sanjivaya National University. So, under the Act, any jurist can be appointed as Chancellor. So, he was appointed and he served as Chancellor for this university for 2 terms. First 3 years and next 3 years. Then the Act was amended and Chancellor should be the Chief Justice of Andhra Pradesh High Court. That's why he is the first Chancellor, and he is more than all these administrative positions. He is an academician, and he was the first PhD holder in Central India. From Nagpur University, when he got the PhD in 1978. That too, his guide, Professor C.G. Raghavan, a very well-known jurist, guided only Professor Lakshminath as his scholar. Under his guidance, only Professor Lakshminath got the PhD, but Professor Lakshminath gave the guidance to the PhD scholars like me. We are all his scholars. So almost our Professor Sachinarayana, the founder Vice Chancellor, is also his PhD scholar. So he did his PhD on state diocese precedent, and which is recognized as a well accomplished book, which was quoted by the Supreme Court judges several times. For his credit, several Supreme Court judges were his students, particularly Professor S.A. Bobde, the former Chief Justice of India, and 4 or 5 Supreme Court judges were his students. So I am very happy as part of our invitation for the convocation. In spite of his age, Professor Lakshminath came to Visakhapatnam to bless DSNLU community. DSNLU Vice Chancellor, DSNLU teachers, DSNLU scholars, DSNLU students. So he is still I remember what he taught in the class. I was a student of LLB in Nagpur University. At the time, Professor Lakshminath was associate professor in PG department, postgraduate teaching in law department, and we were the law students in first 2 floors when I was first year student. Second year, when I was the second year student. Final year, when I was the final year student in LLB. Because of his inspiration, actually I thought of doing practice after LLB. After seeing Professor Lakshminath and others, I wanted to continue my degree as LLM there. So this is macro level teaching of Professor Lakshminath sir, and the micro level teaching I can cite. When I was the student of LLM, Professor Lakshminath sir, there were 2 compulsory papers when I was the student. Fundamental Rights of Indian Constitution and Central State Relations of Indian Constitution. 2 papers are compulsory, irrespective of the branch. I was a commercial student, but I have to complete these compulsory subjects along with jurisprudence. These 3 subjects are common to research methodology. These 4 are common to all the LLM scholars. So when fundamental rights were being taught by Professor Lakshminath, in those days annual pattern, year-end exams, Professor Lakshminath every Wednesday, Article 12 and 13. 1 year he taught every Wednesday these 2 articles. Imagine what type of depth these 2 articles are there. Article 12 state, Article 13 law, coupled with Article 368 and other things. So still I remember he has to give the case law of Article 12. So up to Som Prakash Rekhi in those days, Bhagat Ram and all these cases, particularly University of Madras, whether state, what we say, Wisdom Generous is applicable or not, all these were being remembered by me. Then in second year, Professor Lakshminath and Professor Raghavan are the teachers for jurisprudence subject. So first, no other university adopted this pattern. So textbook wise timetable for the teachers. Still I remember Professor Lakshminath Dayas textbook on jurisprudence and pattern textbook on jurisprudence, CKLN law in the making, sources and others he has to teach regarding that particular subject. Professor Raghavan, particularly Lord Lloyd Hampstead, Introduction to Jurisprudence and Bound Philosophy. Particularly Nagpur University is so famous for the topic Roscoe Pound's 12 concepts of law. So if you open any old question paper of jurisprudence, the last question is Pound's 12 concepts of law. So if you are able to write that answer, you can learn every aspect of the jurisprudence. Because of that knowledge I acquired from these teachers, when JRF and NET was started in 1990, where 50% of the subject is from jurisprudence. So I was able to clear JRF in the first attempt in 1990 when it was introduced because of Professor Lakshminath and Professor Raghavan. So that is what is my stand as a teacher. So I am very happy today Professor Lakshminath is emeritus, and I request Professor Lakshminath to give his erudition, and before that a small felicitation, sir.
To your esteemed Vice Chancellor for having given a very, highly high words, and he has praised me so much. I don't know whether I deserve or not, but I must at least now come to his expectations, or the expectations by which he aroused in you. He has captured the attention of all those people who have attended the 5 convocations meshed into one grand and gala convocation, and therein I think many people have applauded and they have sent accolades and also encomiums, which he richly deserves. And in fact, I am extremely happy that he could do so well where people are doubting his capabilities. So this is something which is another feather in his cap. In such a short time, he has taken such a big event. And even see those people, whether you come justice independently also they have told me that they were not happy. So, Vice Chancellor, I really congratulate you for having. And these congratulations they also partly go to you because you are also responsible for this. So with these two words, basically it is a constitutional offense. Therefore, see, I would like to dwell on the Constitution. And many a time I could see that some of the most of the students, they are not able to distinguish between what is a constitution and what is constitutionalism. Because these days, in fact, for the last 10 to 15 years, the Supreme Court also has been using constitutionalism, but without knowing what are the contours of this constitutionalism. And sometimes they mix up the constitution with constitutionalism also. Well friends, constitutionalism and constitution, these are absolutely two independent concepts. I will start with constitution is the text, constitutionalism is the context. So a country or say a state might be having a constitution, but it may not have constitutionalism. Because constitutionalism is nothing but, broadly speaking, rule of law. Whereas constitution is merely the text embodying the principles of those rule of law, and that is very that it is whether they practice or not, but it is embedded in the textual context, as you see the Constitution of India. So to illustrate this one, during 1939 to 40 Adolf Hitler, that is Germany, it has a nice constitution with some of the basic concepts which in fact no other constitution in those days was having. It's a perfect constitution, including, I think Article 10 also, they said that basic structure, which we had invented in 1973. Imagine it was there in 1940s. But this was a constitution implemented by Hitler. And it's a perfect constitution, but no constitutionalism. Because Hitler was not answerable to anybody. So what is constitutionalism? Then come to the case of UK. UK, even today, it does not have a constitutional text as we see the constitution for us. But through conventions, it adopts the spirit of the constitutionalism, though they do not have the text as a constitution. Because it is made up of several conventions and several acts, and mostly Human Rights Act of 1995, it sets out the limitations and what supposed the Parliament may pass a law and may not pass a law. That means even without there being a constitution, England was governed by absolute rule of law. As you all know, this is what the A.V. Dicey, the person who written a book known as The Law and Public Opinion in the 19th century. It clearly says England is ruled by rule of law. So, we the people, we are ruled by law, not by men. Men means it is absolutely according to your own whims and fancies, as in the case of Hitler. Particularly, when England, without having text constitution, it has constitutionalism. Whereas Germany, though it does have a constitution, but it has no constitutionalism. So what are the ingredients now which you need for constitutionalism? As I earlier said, constitutionalism broadly means rule of law. What is rule of law? is absence of arbitrary thought. So what are the main ingredients? Particularly when you are framing the Constitution of India, I think it was Granville Austin, you must have heard. His first book was in 1966, that is Cornerstone, Indian Constitution, that is Cornerstone. Then in 2000 or so, 2000, he has written another book, Working of the Democratic Constitution. There he has summarized what Nehru has envisioned to be the Indian Constitution. So this course is reflected on the objectives resolution which he has moved on 13th December 1946, because on 9th December the Constituent Assembly met for the first time to draft the Indian Constitution. When we have assembled for the first time on 9th December 1946, to remember the date very carefully, you remember Sonia Gandhi. Sonia Gandhi was born on 9th December 1946, on which day the Constitution fathers, they met. And first and foremost, the Muslim League people, they have not joined. And of course there was much discussion going on and agitations were at peak, and resultantly right from that time onwards, or rather say right from 47 beginning onwards, they had to go in for a separate constitution for a separate country which is carved out of India. So on 9th when the Congress Assembly met, when the Muslim League did not join, and the famous advocate and also the father of Pakistan, Muhammad Ali Jinnah, he wanted a separate state based upon religion. So for this purpose he said no, two-nation theory based on religion. And because of his insistence, Muslim League has not joined. Therefore, this Constituent Assembly has become assembly only for drafting Indian Constitution. On 13th, Nehru had to introduce objectives resolution. So when objectives resolution was introduced, there he wanted, the main thing is that India is Bharat, is United States of India. That was how she was called as. So they wanted to bring an American pattern, and therefore it was United States of India. But subsequently, all this, the joining of the Muslim League has not taken place. Therefore, they have started India, that is Bharat, shall be a union of states. You must be hearing this several times from Rahul Gandhi. He says United States, India, that is Bharat, shall be a union of states. Unfortunately, he has not properly interpreted this one. I'll come to that. So having said this articles of this objectives resolution has become the core of the preamble when it was adopted, particularly on 22nd January 1947. So slightly they have changed because by that time, since the Muslim League has not joined, they had to make it a separate one. And most important of that one was because they have seen the horrors of partition, where the trains coming from Pakistan, Karachi, Lahore, Karachi and all this, no train was carrying any body fully with all the limbs. All trains were coming from Lahore and Karachi, they were all severed into various parts. Limbs cut off, and then it is not water that was coming out, it was actually blood that was oozing out from most of the compartments were coming from Pakistan. That was a horrible situation. And added to that, again, in the eastern side, locally, where you see Jinnah has given say a call, direct action. Call these people and then kill them. That was the situation, particularly during 1947. And this was worse, particularly on 14th and 15th August 1947. So this has prompted, because after 1947 January, they could meet at least for almost 1 year. Then they have to recreate the constitution itself. And it is there, he said that one of the most important aspects which Graham Austin emphasizes is that India shall be a union of states, and they have corrected it. And unity and integrity, this has become a very important aspect, because unity and integrity it has used. And even 16th Amendment also, it has reiterated unity and integrity, because now that the country cannot afford for again another separation or another one, it has become the most important one. It is actually a seamless web as far as the Indian Constitution is concerned. Then they have to create institutions and that to with spirit of democracy, because we are not yet accustomed to democracy. We are all ruled only by the British. As a result of which we are not considered, and rather democracy was never our goal. The third is almost like a socialist revolution. So this has been embodied as it is in the Constitution of India. And the funniest part here is that, see, we the people of India, it is how it has come. Secure. Remember each word, because each word is drafted by Dr. Ambedkar so meticulously. Secure to all the people of India. No, we are not getting any money from anybody. This is we the people, we are giving this. And we want to secure this. We want justice, equity, justice, social, economic and political. Securing. And then promoting fraternity among all, and assuring dignity of individual. Please remember, fraternity and dignity, they owe their insertion to only Dr. Babasaheb Ambedkar. It was not even discussed. In February 1948, without anybody's knowledge, it was Dr. Ambedkar who has introduced fraternity and also dignity. Because without these two things, your justice, social service, they are of no use at all. So this, if you remember, I think Young Advocates Association, that is also known as Sabarimala's case, Justice Chandrachud, Chief Justice, has used the word dignity 121 times. Dignity, individual dignity, because India, unfortunately, has never respected others as equal. You may have, equality, but if you can't respect the dignity, if you can't, move with dignity as others are considered, it's of no use. And this needs, because the state may give you justice, economic, social and political, but can it give you a fraternity? So that's why these things are slowly embedded in the fundamental duties chapter. They have said they have to encourage the composite culture, that to be the scientific culture. So this is what Dr. Ambedkar has appreciated, and he gave more importance to fraternity and also dignity. This you can see, if you go deeper into this aspect, what he thought in those days, it is something even today also they are not guaranteed. Dignity, and if you don't have, if you cannot promote fraternity, it's of no use. Anyway, coming to this is what has been carried out. And this preamble, I can say, it is a key to open the minds of the constitutional creators. So if once you can understand, see what the preamble is, almost I can say that you have understood the entire constitution. Because from this we can see three strands. One is unity and integrity of the country at any cost. Second is a social revolution with building up institutions for democracy and also injecting the spirit of democracy in all the people. And third is economic freedom. These three you can see in any article you find. Coming back to this, what are the essentials of constitutionalism? The first and foremost is that supremacy of the constitution. The constitution, whether written or not, it is considered as supreme, and everyone owes his allegiance to the constitution of India. Number two, there is always a separation of powers or distribution of powers. This you find is in union-state relations, how the power is distributed, and also vertically and horizontally. So separation of powers. And third is social revolution. The third is fundamental rights. Fundamental rights act as external checks. And for these, you can see Article 38. The legislature cannot make any law taking or abrogating fundamental rights. That is Article 38. The state cannot make, the state shall not make any law which is abridges or takes away the fundamental rights. And further see 245 and 246. There is a restriction as per the exercise of legislative power. And in addition, the most important, because even Supreme Court also has forgotten, because it is more eager to safeguard its own existence. Supreme Court is actually more worried about hegemonial impact. Hegemony, because it wants to control the constitution. Through that, it wants to control the complete country also. Here, particularly, I think if we divide the country's period, naturally, we take three phases. One, 1950 to 1973, you can see, till the basic structure document has come. Where you see that court has played a subordinate role. Rather, the hegemony, as far as the legislative supremacy is concerned, is a parliament who don't want to touch it. 73 onwards, almost up to 93 also, it has safeguarded the people's liberties and particularly expanding Article 21, expanding Article 12. By making this, what they have done is, they have rather, justice has been slowly changed to encompass the widest possible meaning given to life and liberty and also freedom and the state. This is what is known as slowly without the knowledge, and these are non-enumerated fundamental rights. They have been expanded without our knowledge. This is what we can say is transformative justice. The existing provisions are already there, and those things have been totally given. Article 21 is already there. But what is Article 21? Life. What is life? Decent life. What is decent life? I mean, decent if there is it has no boundaries. You must have good education, you must have good, so many things are there. Similarly, freedom, without any inhibitions. So like that, you see, they have expanded the scope of liberties. And in fact, all the reforms during 1975 to 1990, all the reforms about the Article 21, present justice and all this, where you find the expansion of the word life and liberty. And in the 21st century beginning, slowly we have become attuned because of I think 1993 change in policy and you see liberalization, globalization and LPG. Because of that, so many reforms have to be taken so that you can eliminate or remove poverty and bring the nation in conformity with 21st century globalization. And our entire economic planning also has changed. I think during that time, the fundamental rights for almost were curtailed for economic justice. And the governmental policies all were upheld to see that globalization is made more smooth. But during the last 2 decades, the court has become, I think people are feeling a little bit sleepy. Is it boring? So during that period, what happens? The hegemonic control of the entire constitution has grown or has been observed by the Supreme Court during the last 20 years. You can see everything they say it's ours. Everything. So the result is the constitution has been, the interpretation of constitution has been monopolized. It is rather, we can say, the hegemony. That means it is judiciary which wants to control the constitution and thereby the other organs also. Including, you have seen, 113th Amendment is the result of excessive power exercised by the court in curbing the discretion of the governor and the president, including the president. You see, president is the person, only a person who takes the oath that he is the guardian of the Constitution of India. All others, they have to work under the Constitution. He take their oath. The only President of India, he being the Supreme Commander, it is he who undertakes to see that the Constitution is safeguarded. So the Supreme Court goes and tells them, you are under my control. If you don't sign anything which is that becomes automatically law. I mean, this is see to what extent the Supreme Court wants to control that. And the result is, all these three, they were envisaged to be constituted bodies. Because these are the bodies which are constituted by the Constitution. Constitution is supreme. From out this Constitution, these three organs have come. It is just like, Constitution is the order. And these legislature, executive and the judiciary, they are its children. But now what this judiciary has done, you are not my father, I can even change you also. I am your father. That means child has become grandfather. And constitution has become parent. And judiciary has become grandson. So not judiciary, the legislature and the executive, they have become grandson. Particularly see, if you notice, 1973, when the constitutional basic structure was enunciated by the Supreme Court, they said basic structure. What is basic structure? It is for us to say what is basic structure. And then what is the most important aspect of it? They say independence of judiciary is the basic structure. Anything you touch, they say basic structure. So that means legislature's powers are reduced. The executive powers are only reduced. And in this way, they have put so much embargo on access of powers by the legislature. Because legislature is meant purely for law making. And judiciary has taken it. Can it do that? Because we normally, when the judges come, but are they really justified? And they did not find the most important big check on the Constitution, that Article 3 to 6. In fact, 3 to 6 is a very important article, and that should have been declared as a basic feature. 326 is adult franchise. Any person who has completed 18 years of age, suppose tomorrow they say, only those people who are about 60 and above only can vote. So you are all outlawed, that's all. The Constitution, the Supreme Court has never felt. And now see they are shouting at it. Foreigners Act and see then the division of the roles and the electoral growth and all this. If that really happens, what will happen? Anyway, coming to this one. This is the aspect see which the constitutionalism takes into consideration. Then there are other neutral bodies. They have nothing to do with the electoral politics. And it is a great innovation as far as the Indian Constitution is concerned. And this one is because there are some institutions, they are politically neutral. The first and most important politically neutral body, that too with coercive motion, coercive power, that is Supreme Court. Second is, we can say, the Election Commission. These are the most important organs, politically neutral, whatever party may take, but these are the two which guarantee your liberties and the Constitution of India. And in addition, we have got some other bodies, such as Control Tribunal of India, then the Attorney General of India, and civil servants. So these are again politically neutral, because a government may come, may be there for 5 years or 10 years. But a politically neutral civil servant, when once he joins, it will be there is for at least for 30 years. So you may take any policy, but these people must be able to continue that policy. There should be a continuity as far as the nation is concerned. And within that, check. Because the majority rules because the minority also. Because minority should oppose, or as an opposition party, it must also have healthy opposition. Because if once the party in majority, if it loses, the opposition party will come again with the majority party. So with that responsibility and responsiveness that this constitution promotes them. It is these features that once they are completed, it becomes known a responsible constitution. And these are the things which should be present constitutionalism. Though they are there in the British Constitution, though there is no constitution as such, British Constitution also the various conventions were put together. British Constitution is more about rule of law. And here you see this one. This is not something you see which is new to us. Constitutionalism has been there right from the beginning as far as India is concerned. Even without taking lunch, how is that we are feeling sleepy? Anyway, it is not my job. So, even without regular bodies, for India, constitutionalism is not new. Because under the national, NPA, National Education Policy insists that we must also have a little bit of knowledge with regard to the Indian knowledge system. So to what extent we are constitutionalized? It's not that merely you simply read the constitution. You must be in a position to understand, digest, and also become a constitutional person. How can it be done? You have to inspire, you have to institutionalize, you have to be constitutive of the constitutional values. So we have to educate them and we have to make them as a constitution. That's why as far as we are concerned, I mean Indians are concerned, we are not that way very different as far as the constitutional aspects are concerned. If some of you have got any idea about Arthashastra, written by Kautilya, was it Chanakya, anybody may call. He has given the first, I can say, secular constitution as the Arthashastra. Arthashastra does not mean political economy. It's not that. It is a bad translation. Artha in Sanskrit means not merely paisa. Artha means livelihood. The science of livelihood. What is the science of livelihood? That you can see now. We have got 18 chapters in Arthashastra, and almost everything is secular law. Kautilya in 375 BC has envisaged a secular law. Can you imagine? And unfortunately, the existence of Arthashastra was not known to India till 1905. That's all those writings by British so-called researchers was absolutely wrong information. Because I think Ashutosh Mukherjee, perhaps you must have heard his name. Sir Ashutosh Mukherjee was a great scholar. He was also Vice Chancellor. He was also a great judge. It was he who has recommended those people, why don't you study our own books? So in 1905, a book by Kautilya was available, and then it was translated. And when you find it is just nothing but the Constitution itself. Oh, do you remember Article 12 and 13? Article 12 and 13 is the Constitution of India. So Article 12, I mean, if you remember also, you know, have you heard about Kelson? Hans Kelson. Hans Kelson was known as a monist. Monist means like Shankaracharya, Advaita, Aham and Pan, both are one the same thing. Jivatma and Paramatma, they are one the same thing, but one look at different angles. See, I and you, if you become one, it becomes we. If I and you, if they become one, it is Advaita, and there is no difference. So this is how we have tried to bring in, just see juxtaposition between Article 12 and 13. Article 13, first, pre-existing laws, 13.1. 13.2, post-constitutional laws. And Article 13.3, it defines what is law and what is not law. So that law in Article 13, you can say it is abstract. What is that? A contract. Whoever see promises, whoever see consideration is there. But only after taking that money, if you don't give back, then contracts are coming to force. So till it comes into force, it will have only verbal effect only. Only when you don't receive, conform to your received promise, then only you go to the court. And then the court will receive sanction. And then you will be liable to do anything, like crime or torture. So that's why. Actus non present rape, deceivance, we are also there. So act alone, you may intend anything, but it should be translated into act, fact, and emotion. Like that. So in all these aspects, one is there that is law, but the machinery through which law is affected, that is also equally important. You all want to become advocates. You all want to become GA, LLB. But how do you become? The institution should be there. This is a mechanism. So you have to pass your 12th, then you have to clear your track, and then come here, complete 5 years. So this is the mechanism or institution. That is the idea. You must get your BA, LLB. This is the institution. And then you become an advocate. So this is how we see that. So in the case now with Article 12 and 13. So abstract law you find it in Article 13. And where do you get, how do you get this law? In fact, if you read this further Article 3, Article 12.3, personal law, then you see law of the company, all the things. They are not coming within the concept of law. But then there must be somebody who has to make the law. Who will make it? That is, just see Article 12. Article 12, it says state. State means and includes. State, they are not given as an exhaustive definition. That is one of inclusive definition. State means nothing just for all of them. Then is the legislature, executive, all this. Then is the panchayat, and also the state, all this, including. And the judiciary, from time to time, it went on increasing that list. So what all that state, that means state is concrete, you can see it. You can see parliament, you can see executive, you can see a state legislature, you can see a municipality. This is a concrete one which makes the law. And what they make, a contract act, also is Environmental Protection Act, that is abstract. So one is concrete, other one is abstract. This is what you see, Kelson says, law and state, they are not two. They are one and the same thing. So, this is where sometimes, Dvaita and Advaita, they meet only one. Shivaya Vishnu, Vishnu Shivaya Vishna, Shivaya Vishnu Rupaya, Vishnu Shivaya. So, if once you believe that God is one, therefore it becomes a monistic theory. That is what Kelson said, law and state, they are not two different things. They are one and the same thing, but look at from different angles. If you look at from the concrete angle, it is state. If you look at from the abstract angle, it is law. Whoever is enters into promise must perform it. So one is a concrete one, other one is a. This is what was envisaged in 375 by Chanakya. Because it is all seen during this what Nanda dynasty. They have become so rigid. There was absolutely anarchy. In the absence of state, if they don't properly rule, it becomes anarchy. Arachakatva. So when it goes to anarchy, naturally, no Raja, even Raja is there, nobody cares for him. So therefore what Chanakya did was, he sought out, he went in search of a person who can provide leadership, who has got leadership qualities. So from Maurya dynasty, he found Chandragupta. He got hold of him. He took him all the way to Takshashila. Takshashila is 1,000 years old university. He trained him. But those days they are not universities, they are multi-universities. You can have any type of education, all types of education, like Nalanda, Takshashila and all. And he trained him, even Rajaniti, and including horse riding, Tattva, Vedanta, all these things. And he made him perfect Raja. And he brought him back to Bihar. And there he made Pataliputra, I think, capital. And he said, you are Article 12. You are the king incarnate. You are visible. You are the concrete one, Raja. And you rule about these principles, rule of law. That is Arthashastra. Arthashastra, Shastra, nothing about the livelihood. So, Article 12 is a concretization of the law. Article 13 is the abstract of the state. And what they do is, Article 14, rule of law. You are not answerable to anybody. You should not be anyway arbitrary. You should obey the rule. And law, whatever is statecraft you do it must be in accordance with the law. You must be ruled by law. and it should not be going on because it becomes bureaucratic, it becomes arbitrary. So, absence of arbitrariness is the presence of rule of law. That is how you can see 12, 13, 14. They were seen at same place, rule of law by the state and the law. This is the beauty of the constitution, where you can see the abstract rules and the continuities of state only for the purpose of administration of justice. So these are the various concepts, which, I mean, if you think over, you understand these things. I think with this, I think we will stop it. So even this also, I think I may get into some what we call recent judgments. Supriyo Chaudhary, Supriyo Chaudhary is that is about same-sex marriages. Because these are all some things which are anathema as far as our own country is concerned. Unfortunately, that's why, to what extent judicial behavior is reflected by the environment in which he was brought up. See, Justice Chandrachud always lived in high-profile Christian road, I think, always, right from the last 40 years or so, and having gone to Harvard. So his views are always whatever is the best, it comes from the best. Best is the best. That is. But all that comes from best is not the best. All that comes from the best is not the best for the best. We do have our own values. That's why, if you remember, Ravindra Bhatt, another judge, in the same-sex marriages, there he says that your morality as you think, because they think that they are everything. There is no public morality as such. There is constitutional morality. What is common morality? What we say is common morality. But what is morality for Chandrachud is not morality for you and I. I don't think you agree with Paul. And he says, same-sex marriage, right from it has been going on for the last 15 years or so. And he says, I want to interfere, and he says the same-sex marriage should be validated. And you must make his Special Marriage Act allows that one, and that provision is valid. Having said that, see the unfortunate position. There are 5 judges, and the Chief Justice of India, a very powerful post, he was a minority. And he writes some 300 pages about why same-sex marriage should be legalized. And all the 4 judges, they were not listening to him. Society's morals like society's habit. You are nobody to dictate. This is the morality. So public morality is something which is different from your morality. And you can't impose your morality on people. And constitutional morality also nowadays there. What is constitutional morality? It is nothing but the faithfulness to the Constitution. So this is what we call, it has certain values. And these values are redemptive constitutionalism. And from this redemptive constitutionalism, you want renaissance of the Constitution. From renaissance now it should be democratic constitutionalism. Because the Constitution must be more democratic. It cannot be what the court says. Throughout for the last 10 to 15 years, they are saying, see, constitutional morality, and what is it? There is no constitutional. What we say is constitutional morality. What is the guarantee? That's why again the court said, courts are not there to determine what is constitutional morality. Let public evolve. When the public, if they come to the stage, let the public do it. Public morality you can't identify with the constitutional morality. This is different and that is different. That means you cannot pollute the public morality through your so-called constitutional morality. That the public evolve its own morality. That is when this is not our job. And the same thing, it is not the rule by judiciary. It cannot be juristocracy. This is democracy. The people develop And what is constitutionalism here? You have to develop that type of democratic spirit in this way so that they can have faith in the constitutional morality. We have a faith in the constitution that it is there for us to develop our own constitution. And in this process, we have definitely economic constitutionalism, political constitutionalism, and what we call civilization, cultural respecting constitution means it is no constitutionalism, but at the same time you should be not merely on the morality. There is also another concept of constitutional maryada. Constitutional maryada means respect, constitutional courtesy. But this is your sphere, I am not open. This is your sphere. But everything I want to take it. How can it be? You say that I dictate the morals to public, can you accept it? That's why I say whatever is best for the West, whatever is best for the West, whatever is best for the West is not the best for the East. But we unnecessarily import those things. Like those so many things nowadays, all. So here, you have to develop a balance. And this balance will be to respect each other. You respect public morality. And we respect judicial morality. You, as long as you don't interfere, it's all right. That's why Ravindra Bhatt said it's not our job. Let public involve its own morality. So that, as we are saying constitutional morality, there is also another rider, that is constitutional maryada. Maryada means you be in your sphere, I will be in my sphere. Don't touch them. Whatever strictly falls into the constitutional contours, let us decide. These are the things because how the economic distribution. From economic distribution, we have gone to economic redistribution. This economic redistribution comes from Keynesian. The post-Second World War, there is nothing. I mean, you must have heard about Rawls and all this theory. It is nothing but economic redistribution. Then came recognition. Then came the culture. Culture of what? Respecting the culture of individuals. And in a political community, you must see always respect the identity of other groups. Such as indigenous tribes out there. They have their own culture. And this culture should be recognized. So one redistribution of wealth. Second is recognition of culture. And third, this is regarding the recognition of political culture. The shift in political culture where are we really having democracy? How many of our voices are heard by the legislature? Just human. We have a ear, but is our voice ever heard by anybody? Nowadays, at least in India, we have actually one concept. That is what they started as encouraging. That is the 1980s onwards. Right from second judge's case, that is Gupta, SP Gupta. That is what was even Ratlam municipality. Public interest litigation. Because what happens, the lawyer, whether it is a great Kapil Sibal or is a Singhvi, Abhishek. These people who give the ruling, real judges are afraid of them because they shout. But are they representing us? Huh? They are not representing the people. Huh? This is how are we really represented? जिसका लाठी उसका भैंस. When I get to Kapil Sibal, and then this will also hail. Then this is stay granted. And even before court pronounces, it is already stayed. Jahangirpura cases. At 10:30 the court opens. And at 10:25, she call enters. And 10:20, order is already passed. And the bulldozing is happened at 10:30. And you see, stay order, she goes at 10:25. He goes with the copy. And the copy is already in hands in the midnight. And that is an open one. That is only the judge. He openly admits. There is a press go. And even before action begins, stay. This is how you see it works. Right, therefore, these are the people who say that politically you are very important, and this is this what we call participatory parity. We all have votes, but we have no voice. 140 people, because of course I don't want to go into those things. How many of our voice is heard? There are only certain lobbies, and that's also accordingly law is made. But judges are not going to hear, politicians are not going to hear. Even today, you think just BJP plus some other parties are there. How many they represent? Out of 100 people, only 50 people vote. Out of the 50, 26 people, you will get 26 votes. When it is 26 votes, the winner takes all. So, out of 100, if 26 people, if they win, you get that vote, that means the entire democracy is yours. Whatever depending 74%. This is what is known as John Kenneth Arrow. It is social choice theory. Because you are not allowing people to be represented. Their voice remains voiceless only. This is a political recognition. Politically, are you really representing properly? No. So that's a call that participatory practice, if that is not there, it is no democracy. Actually, people's participation is very important. That happens only in what they call the democratic constitutionalism. In a policy where is a democratic constitutionalism, the people they take part in making the laws, policy, in executing the law, and also in the process of deciding the case. If a case is decided, can you change the law? Today somebody is pumping so much money, he wins the case. And or lawyer also argues the case only. But law has not changed. You need, when you have to be democratically, you have to bring a change. You have to bring a dialogue with the people. That is participatory parity. Both this ruler and the ruled, they must have parity as per the participatory. And here you can reveal your constitutional values. But there these values are not. All these organs are supposed to work equally without usurping the powers of the other. It is not happening. If this happens, that is the day on which you can say democratic constitutionalism, or that is democratic justice. To provide voice to the voiceless. You provide voice to the voiceless. Millions of people, and thereby you bring, a shift in the culture, legal culture. That is where you are successful in PIL litigation. Because Narmada Bachao, who is there? All tribals. And their voice was heard, the court was made to hear. In Godavarman's case, because the forest dwellers' rights. So these are PILs, or the way to shift the culture, to legal culture, but so to say, to bring in reform. Otherwise, if you people go to the court and the lawyer is there, he is heavily paid, and the matter is easy. But that is not going to change the law, that is not going to change the legal culture. And this is what exactly you say, constitutionalism, and particularly redemptive constitution, because it is a constitutional faith. But before that, in 1947 and 1950, the people have made faith that this constitution should give us this. Has it given? If they have failed, let us be party as far as the parity is concerned. Let us discuss and give these values to us. Okay then, thank you very much. Thank you.
This must be the
You said that judiciary, in constitutionalism, is responsible for maintaining the constitutionalism. As far as we read that judiciary is responsible for constitutionalism, but you said that's overstepping the power. So, what would be the real mechanism for maintaining the constitutionalism in our context, in Indian context?
What is all responsible? Because every organ has got its own responsibility to maintain what we call constitutionalism. If one of the organs fails, the other organs no observes. Just as you see, US Congress was a very weak one. And initially when a constitution is drafted very loosely, using you see very wide phrases, that is what has happened in American constitution. Then judiciary has become stronger. So it is how you see you make that is what checks and balances. So if checks and balances are proper, like we have Article 226, Article 32. These are checks. If you are exceeding your power, the court, and here you see, court also must equally be responsible because people should be in a position to respect the court's order. But if interfere in everything, the executive will find it a very embarrassing also. That's why I said no. We have to observe constitutional maryada, constitutional courtesy. Legislature has exceeded in 1967, Kolarna's case. Therefore, she has put some type of law obstacle. He has created. Thereafter, again, they have further went because till 1967, the parliament was strong enough. 67, what was there? After the death of Nehru in 64, there was not so much of instability, political instability. Therefore, judiciary was movement. And in 1973 or 1975, judiciary was buried. Then what they were doing? And then they were saying Indira ki Jai. So only 1976 or 76, so when the Indira Gandhi, etc., when they were defeated, then they have brought 44th Amendment. Who brought it? Don't dig any of these organs, it's only people. Because they rejected wholesale Indira Gandhi. And they said you have buried the constitution. And they got it. And 42nd Amendment they have totally repealed. And they brought to 44th Amendment. So this is democratic constitutionalism. And that was later approved by the court. They were for 1961, they said legislative supremacy. That went on up to Supreme Court judges advocates on resources up to 1999. So 1999, yes, we are supreme because legislation was weak. So this is somehow it goes on. So ultimately somebody has picturized this as legislature with judiciary. And ultimately, as you said, whatever is comes from the West is not always the best. Our own institution, they have to fight against each other. Then only something healthy development will be there. That's why this whole same-sex and LGBT, this so much of the judgments have gone into it. And the result is now everything subsided. Because our society is not prepared for that. They impose from there. Hardly one man saying he cannot change 140 crores. Okay.
So when we talk of democratic constitutionalism, institutions like right to information play a major role when it comes to power of people. But
I am not able to hear you. Come here. Justice as fairness. Somebody said pattern. Justice is a irrational idea. But now I see Mr. Devanshu. He said that, sir, arc के बारे में
Well, friend, the problem here is that, in fact, whether it is Rawls, whether it is Dr. Ambedkar, all the people, now in such a big democratic country, you cannot get justice, nor you can ever see procure justice. In fact, most importantly, this is what Charles Dickens, in his great expectations, he starts with that. As a child, he sees everywhere injustice, injustice, injustice everywhere. So when you are facing so much of injustice, how can you think of justice? That is what you see Amartya Sen is the idea of justice. If you cannot do justice, at least try to reduce injustice. This is remedial justice, what we call. See, because institutions, they cannot be changed. Because the men you see who are important. Can you really bring equality? But you try to see there is inequality is again. Right to Information Act is only to make the authorities give the information. They cannot cure it, but they will tell you why injustice has been done or not done. And if you can cure it, well and good. So this is one of the days, Shelke, I think somebody has written, how to reduce injustice. That is on what's particular, see, if you analyze all the recent decisions given by Justice Bhushan Gavai, he was orienting towards, but let there be less injustice, let there be less injustice. That is what he did in the Punjab case, Devendra Singh versus State of Punjab. Then he said, in these cases, subcategorization of scheduled caste, scheduled tribes. If you cannot do justice, at least do not do injustice. If the homogeneity is there, there will be injustice. Therefore, that you can reduce it by bringing in heterogeneity. That sub-classification among scheduled caste for the purpose of Article 15, 16 and all that. So that is how the present day is that where you cannot do justice, at least try to do minimum injustice or reduce injustice. I think in that category, this RTA also comes in. That's all.
Lakshminath, my Guru. So, extended an excellent lecture today on various aspects on constitution and constitutionalism. So, what is the difference between the two? Sir has enlightened us in a greater way. And in addition to this, the relation between Article 12, 13 and 14, how they are correlated and to what extent they are having the relation. Advaita, Dvaita, what Sir has explained in a greater way. Sir, we are very grateful to you, sir, in extending an excellent lecture to our students, the 5 years as well as the first year students. Thank you, sir. Thank you very much for listening.